May I please, your lordships?
Yes.
Item 47. This is a matter pertaining to the land dispute between two villages. And in this case, by an order of this honorable court, Dr. Masa and me have been appointed as the conciliators to mediate. And series of meetings have been held. Sport verification was also done. The matter has been resolved to a great extent. The parties are not meeting to a point in a small portion of land for which the negotiation is still going on. And we are hoping that very soon parties' good sense will be prevailed on the parties' lordship. So another 3 weeks time may be given to enable us to make a sitting lordship.
On the prayer of Mr. C.T. Jamil, London Senior Counsel, who has been
I have
appointed,
taken the consent from Takamasa also, who is representing the other side.
who has been appointed as a mediator.
Yes. Conciliators.
In the cause list, it is shown as a mediator.
Yes. Whichever way, it's okay.
Shall we say mediator or
Yes,
conciliator?
Lord.
Okay, mediator. With the consent of Mr. Tanka Masa, London Senior Counsel, who too is a mediator. List this matter after
3 weeks.
Okay.
Much obliged, Lord.
May I please, Your Lordship? I beg to mention item number 41. My
Yes.
Lord, here I'm yet to receive instruction. So kindly allow me 3 weeks time, my Lord.
41
Yes, my Lord.
after 3 weeks. Okay.
Much obliged.
May I please, my lords? Lordships, I beg to mention item 38.
Yes.
Kindly grant us 3 weeks time to file affidavit in oppositions.
All right. After 3 weeks.
Oblige, Your Lordship.
Please, Worships. Lordship, I beg to mention item 44, 45, and 46.
Yes.
If this matter may be taken up next week.
Okay. List it after the week. Let's pray for.
May it please your lordship, I beg to mention for item number 43.
Yes.
Lordship, yes, on behalf of Mr. Prosecco, counsel for respondent number 3 to 5. Lordship, my senior is in bereavement. With the consent of the petitioner, kindly list the matter on June 7.
Okay. June 17. Listed on June 17 as per. All right. June 17.
Mashallah.
Any objection? Or else?
No objection.
I pass the order.
May I please, Your Lordship? My Lord, in item number 2, that is analogous PL.
Yes.
So we have filed, State and Department, we have filed affidavit only this morning. So we may be allowed to take up after that PL 1 of 2022, the timing adjustment.
You want an adjournment of this
No,
case?
no, not adjournment, duty itself. Because followed by the analogous PL, there is a PL 1 of 22, PL Somudu. So if the PL 1 of 22 is allowed to be taken up first, followed by the analogous PL.
PIL 1 is which item number today?
That is 36.
36.
Yes.
Okay. You want 36 to be called up before item number 2?
Yes, yes, Your
All
Lordship.
right. All right.
May it please, my Lord. In item 36, my Lord, I am for the respondent number 10, the authority engineer. I have filed an affidavit this morning, my Lord. If it may kindly be called. Please, my Lord.
Yes, all right. Yes, yes.
For motion item number 1.
May I please, Lordships? Lordships, as per order dated 26/4/2023, this Honorable Court directed the appellant, Lordship, to submit a fresh spot verification report of the concerned municipal council. Lordship, however, the municipal council's author, the administrator who will issue the certificate, he's out of station since last week. And Lordship, in that eventuality, we are yet to receive the certificate from the concerned council. And that is why it could not be produced before your Lordships today. However, Lordship, this honorable court earlier, in earlier occasion, has queried that why this first appeal is before division bench, and has also queried that this should have come before the single bench, Lordship. And after I had an interaction with my senior, Mr. S. Datto, in the principal seat, Lordship, it is, Lordship, as per the Bengal Assam Agra Act, Lordship, as per section 21 of the Act, Lordship, I may be allowed to give a copy, Lordship.
Yes, what is there in Assam?
Lordship.
Bengal Agra Act. Yes.
Lordship, as per section 21, Lordship, of the Bengal Assam Act, Lordship, appeal from civil judge, Lordship, if the amount is if the valued, Lordship, is exceeding 25 lakhs rupees, should be before the High Court, Lordship.
High Court?
Yes, it is section 21B, Lordship. May I read, Lordship? Appeals from civil judges, senior
Then it's
division.
all right. It is before the High Court, that's all right.
Lordship, but
What is to be done today?
no, this honorable court has queried that why it is before division bench earlier, and his lordship has said that it should have come before the single bench.
RFA?
RFA, Lordship.
Yes.
And after I had an interaction with my senior, Mr. S. Datto, Lordship, and as per section 21 of the Act, Lordship.
Appeal is against judgment and decree passed by the district
Civil,
judge.
yes, civil judge senior division, Dimapur,
Civil judge senior division.
Lordship. And the value of the suit is 25 lakhs. So as per the Act, Lordship, it should have come before the single bench, as per his Lordship's query.
Is this Bengal Agra Assam Act is applicable in the state of Nagaland?
Lordship, yes,
Applicable.
Lordship.
Then that's all right. Then
In that eventually, Lordship, registry may be directed to list the matter before the single bench.
it will be before the
Lordship, yes.
Single
yes,
bench?
Yes, Lordship.
but you are referring to section 21.
21, subclause B, Lordship.
Section 21 subclause B.
Lordship, page number 18.
Yes. 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 It is below 20 lakhs.
It is 25 lakhs rupees,
25 lakhs.
Lordship.
Which- So here the High Court means what? It is a High Court means refers to what? Single bench or the division bench?
Lordship, earlier it was before the division bench, but now, as per the Amendment Act, Lordship, it is before the High Court. So it is not mentioned about division bench now. So
What does the High Court rule says?
Lordship, I'm sorry, I'm not carrying the Act, Lordship.
You find out.
Lordship,
Huh?
Lordship.
When do you want?
Lordship, on 25th,
On 25th.
Lordship, in the meanwhile, the council has showcaused me saying that why my certificate issued by the council should not be cancelled. And I have replied to their showcause notice. I may be allowed to
What
furnish
certificate?
the certificate issued by the municipal council.
How
Actually,
does the
my
municipal
shop
council
premises,
come in? How does the
Lordship,
municipal council come in here?
Lordship.
When the judgment decree is under challenge?
no, Lordship, actually, I have a shop at Dimapur.
Ah,
And
you have filed an IA.
yes, yes, I have,
We are not considering the IA. We'll consider the main appeal
Lordship, Lordship,
on 20.
Lordship. Obliged.
For admission, item number 36.
May it please the Lordships.
Yes.
My Lords, by an order dated 13/3/23, 13/3/23, this Honorable Court directed the contractor to complete execution of the contract by 30th May. 30th May, end of this month. End of this month. Then the matter came up again on the 12th of April 2023. The contractor as well as the respondents, they were directed to ensure that the order dated 13/3/2023 is complied with and the contractor completes the work by the 30th of May. And the case was directed to be listed today. Parties directed to file their affidavits about the work done. They have filed affidavits this morning. All of them have filed affidavits this morning. I don't know if they have been placed for your Lordship's consideration,
So if the work is to be completed by the 31st of May,
my Lord.
what is the necessity to look at the affidavit today?
At that point, yes, my Lord.
We'll
Today,
post-
it may not be very
we'll-
necessary.
We'll post it up to 31st.
31st is a Wednesday, my Lord. That is a division bench sitting day.
Okay.
So it can be fixed on the 31st.
31st. Okay. On the prayer order counts for the party. This is on 31st.
My Lords. Much obliged.
Lordship, Lordships.
For admission, item number 2 to 35.
Yes, who is appearing?
Declaration, Lordship, Your Lordship, by the order dated
You are representing whom?
state. By the order dated 12/4/2023, the state respondent was directed to submit the proposal of the teaching staff and the staff of the medical college. So we were directed to submit the affidavit. So Your Lordship, here, we have filed only the affidavit only this morning. So in the affidavit, the approval and everything is already put up to the cabinet now. So we are waiting for the cabinet approval. That it is, clearly stated in our affidavit, filed only today. In that affidavit, we have said,
What? In the affidavit, what you were asked to indicate?
post creation,
Post creation.
342.
Ah,
So in that case, we,
post creation.
yes,
You have,
order of this court.
Huh?
12/4/2023. Last
yes,
order.
yes.
There was a direction to the state respondent to file an affidavit with regard to post creation of 342 for the medical college in Kohima.
Ah,
So the state have filed an affidavit to that effect, Lordship. And I also have filed my affidavit with regard to the civil works, the status of the construction that is going on, Lordship. We filed this morning, Lordship.
so this 342 posts
That has already been earmarked,
is to
Lordship.
be created.
Yes. We have,
Is there a direction to create this post by this
no,
court?
Lordship, for the running of the medical college, Lordship,
Yes.
around 800 plus posts is required for the medical college.
Yes.
So out of there, we have got around 400 in position. So an additional of 342 is required, technicians.
Yes.
So this Honorable Court has given a direction to the state respondent to file an affidavit as to what step have been taken.
Okay.
So we have proposed for creation of 342, and the matter is placed before the government, before the cabinet, for approval, Lordship.
Okay.
So they have filed an affidavit to that effect.
So this affidavit is compliance with the
This
earlier order.
court order, Lordship.
Okay. Then what is to be done today?
Lordship, now the matter will be placed before the cabinet. Cabinet will approve it, and once the approval comes, Lordship will do the recruitment, Lordship.
All right.
Because the session will start in the month of September. Counseling starts in the month of July, August, and the class will resume in September, Lordship. So within that time, the post will be created.
Okay. Then what do we do with the PIL today?
Lordship, since we have complied with the court order, Lordship, so till the post is created, Lordship, sometime may be granted to us, Lordship, because we have to wait for the
How much
approval of the
time?
cabinet.
How much time?
It's 4 weeks. 4 weeks, Lordship.
Okay. Mr. Who has filed this affidavit?
Chief Secretary,
Government advocate.
for respondent number 1.
Your good name?
Im Tim Song, additional AG.
Okay. Additional AG. Submit state. Pursuant to order dated 12/4/2023 and affidavit by the respondent number 1 and 2 has been filed today.
Lordship, respondent number 2, 3, 4, 5, and 6 also have filed an affidavit, Lordship, with regard to the status of the civil works.
But we have one affidavit here filed by respondent 1 and 2.
Lordship.
Where are the others?
We have filed this morning, Lordship.
Who was by this 12/4/2023 order?
Lordship.
Who was directed to file affidavit?
The Chief Secretary as well as the medical department.
Which respondent?
Respondent number 1,
1 and 2.
1 and 2,
One-
and 3,
1
4.
and 2.
Yes, 3, 4, 5.
Yes, 1 and 2 affidavit is here.
Yes, Lordship. We have filed this morning, Lordship, for 3, 4, 5, and 6.
Okay, 3, 4, 5,
And 6.
and 6. Okay. 2 affidavits.
2 affidavits, Lordship.
Okay, all right. Mr. So-and-so, Learned Additional Advocate General, and Mr.
And Mozoid,
N. Mozi.
for respondent number 3, 4, 5, and 6.
Okay, for respondent number 3, 4, 5, and 6. Additional AG for 1 and 2. Have submitted that person in compliance with the order dated 12/4/2023.
Lordship.
Affidavits by the respondent number 1 and 2 and respondent
3 to 6.
respondent number 3, 4, 5, and 6 respectively have been filed.
Lordship.
Yes, you are for the petitioner.
Yes, Your Lordship, I'm for the
What
petitioners.
is to be done?
Your Lordship?
What is to be done today?
Your Lordship, since the respondents have complied with the previous order, if the court can monitor till the cabinet has approved.
Indicating that the proposal for creation of as many as 342
Lordship.
teaching as well as non-teaching staffs for the medical college of Kohima
Kohima.
have been put up to the government,
Lordship.
which is under consideration by the government. Is not it?
Lordship.
In view of the above, the council is appearing for the respondents press for listing of this matter after 4 weeks.
Lordship.
To which prayer Miss
El Kinimi.
El Kinemi, learned counsel appearing for the petitioner, has no objection. In view of the above, and is grateful listed after 4 weeks.
Lordship. Obliged, Lordship.
Oblige, Your Lordship.
For admission, item number 37.
Please.
Yes.
My lord, this is a matter pertaining to the election to the post of village council under the Nagaland Village Council Act. Short issue is that one group states that they had given some list to the concerned authority and that they were asked to verify that before the statutory authority. The other group says, we've also submitted a list. I'll give the details just to introduce the matter. We also submitted a list, but the GB refused to accept it. And therefore, we sent a copy of that to the government. When the government received two lists, then an intervention by the government was necessary in terms of Section 20 of the Act. If there is a dispute between the contesting parties, then the authority mentioned there will have to look at it. And whatever they decide is final. When this matter was going on, they both were called to come before the officer only for one purpose, only to verify the list right from the beginning, which contains signatures individually, the date, and the resolution. So we have one set of people who sent a piece of paper sent by the GV, which does not contain the signature of a single person, while the other contains all the details. So once this matter came up before the concerned authority, they directed the AEC, Assistant Extra Commissioner, EAC. Yes.
Before that,
Sir.
can you briefly apprise us how this village council is elected?
How this?
You said it is an election to village council.
Correct.
And how they are elected?
I'm coming to that.
Yeah.
Please. I just wanted to give a brief background. I'll come straight to the picture. Your Lordship is having this act, my lord, or I got extra copy. One more copy. Two copies we should make. I'm just forwarding the latest act. May I draw your attention to section 4, my lord?
Yes.
Section 4. Membership. A village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usages, the same being approved by the state government, provided that hereditary village chief, GBs, and Agnis shall be ex officio members of such council and shall have voting rights. So this is the procedure prescribed under section 4. It is the party contention that this procedure was not followed. So we are purely on this procedure. There are 3 more provisions which I'll quickly go through. The next provision is Section 16,
Section
16,
16.
they're relevant partly for this case.
Yes.
Disqualification. A person shall be disqualified from being selected as and for being a member of village council. 16R, I mean 16(6), if he is a salaried government servant.
Yes.
And then they say 17, if any question arises to whether a member of the village council has been subject to disqualification, question shall be referred to the decision of state government whose decision shall be final. Now kindly come to section 20.
Yes.
When a dispute arises as to the selection of any member of a village council, the matter shall be referred to the state government, whose decision thereon shall be final. Then you may kindly come to section 22, control of village council. Subject to the general superintendence of the state government, the deputy commissioner, additional deputy commissioner, subdivision officer, extra assistant commissioner, circle officer shall have control over the village councils within the jurisdiction. So these are basically the sections which are relevant for the consideration of our case.
Village council consists of how many members?
That is, each village council, each clan will have a village council member. Suppose there are 6 clans. Then in that 6 clans, they will forward the name by mutual discussion, normally, of one person.
Mutual.
Yeah. But suppose they want to disagree, being a democratic process, well, they can have separate lists also. Some may not prefer one chosen by one, so they will put a separate list.
No, this case relates to which village? This case relates to which village?
Botha village. BOTSA.
In the mic.
Oh, sorry.
please.
That's-
Yes.
Botha village.
Botsa village. Now, Botsa village consists of how many members?
6 clans.
Huh?
6 clans.
No, this section 4 says a village council shall consist of members chosen by so and so, etc.
Correct.
So a Botsa village council has to consist of some members.
Correct.
How many members?
6 members.
Okay, 6 members.
Because there are 6 clans,
Ah,
so each clan
okay,
will have 1 member.
okay.
Suppose there is a division of opinion,
So each clan elects
1 member.
1 member.
1.
The dispute pertains to which clan, or all of the clan?
No, they have disputed everything. I am coming to that.
Okay.
Their case is a very magnified case. I will come to that regularly. But this is the point which your lordship has correctly said. This is the procedure in which they are elected. Then after they give the names to the head GB, the head GB, what he does is, he forwards the name to the higher authorities of the government. It goes to the topmost authority.
Just a moment. Village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and uses.
Correct.
Here, this customary practice and uses would be the difficult area.
In fact, in this case, incidentally,
Say,
in this case,
the same being approved by the state government.
correct.
Now, if we have understood correctly, is it election or a selection? Chosen means it's a kind of a, what? Is it?
In fact, normally what happens is when
We'll go by the,
no, I'm saying what they do is when there is unanimity among the members, suppose some particular name is mentioned, very democratic, in front of the head GB, they will raise the hands. We are for this person.
what is the customary practice and uses of Botsa village? To choose a member of a village council.
In fact, May you repeat, my lord, what is the question you asked?
What is the prevailing customary practices and uses of the Botsa village to choose a member of the village council?
In fact, as far as selection of the members is concerned, it is not that the custom really varies. Each clan has got one member. This is undisputed fact, even by the other side. So they have to forward the name of a single member. And the normal routine is
Who has to forward a single member?
the individual members,
Clan member.
yeah, the clan members will nominate a particular person and send it to the GB.
Okay.
Now, once it goes to the GB, if there is unanimity in that person, the GB will forward it to the higher authorities. Suppose some of them chose not to agree with them. In that event, there is no inhibition in law from issuing a second list. If the GB receives it, he has to forward that list also. He is merely a postman.
This dispute is at which stage?
The dispute is the one party submitted the list without documents, other party submitted the list with the documents, and what the GB did, he accepted the list signed by him, not signed by the persons who are supposed to sign, and he sent this forward, and the other list given to him by the members who signed it, he just returned it. He refused to send it up. This is the controversy in this case.
Then this is basically an election,
You can say in a way it is an election.
isn't it?
In a way you can say, but
So under the circumstances, the best resolution would be to hold the election afresh.
to
To hold the election afresh.
no, let me make my submission. It is not.
Because see, perhaps writ petition has been entertained. This is an appeal. Now, if we go by this section 4, I don't know what is the nature of dispute the parties have raised. This, depending upon the nature of dispute that raises on an election of the membership to the village council, evidence may have to be taken into, may have to be adduced. This is a complex procedure, customary practices and usages. How this case could have been decided in a writ petition?
In fact,
Subject to
I will
going deep into
we
it.
will have to go deep.
Yes.
Go a little deep. Even I was thinking the same way.
See, customary practice.
There's no
You will-
misdirection as
you will-
far
you
as
will appreciate.
the sports appreciation is concerned. I agree with it. But when we go deeper, we will see the real truth.
Because we would like to be very clear on the
And we'll
first
make it
principle.
very clear. In fact, what has happened is appears to be some lack of clarity and a little bit of confusion in the single judgment. That is the thing which I'm actually going to clarify. So to begin with, may I make my submission on the facts so that we can see deeply.
Just a moment. This,
Right.
you are representing the state or what? Yes. Now, who are the parties here? There appears to be two parties.
Two parties. One set of parties are the respondents herein.
Just
Lordship, I'm the petitioner.
petitioner.
The person, the group which was not.
Joe is the.
Yes, my lord, and direction is to go for a fresh election,
We'll see.
fresh selection. My lord, the disputing parties have agreed to it. State has no grievance, should not have any grievances, my lord. The other party also has not filed appeal. We also have not preferred an appeal. We are accepting that, okay, we'll go for the fresh selection.
This appeal is by the state.
By the state.
It is the authority of the state which is in question. When the state has performed its statutory duties, making false representations, filing false affidavits, and various details which I shall present before your lordships, and then trying to hijack an election when they didn't have any members. So let me make my submission in a very brief minute. Your lordship will get the gist of it. Kindly bear with me.
Okay, all right.
I'll clarify it unless it's clear. Then it's up to your lord. We'll see.
Because I am sure in the judgment of the learned single judge, this procedure prescribed under the statute, I don't think they have minutely gone into it.
They have managed to.
Okay, let us
Correct.
let us hear you. Okay.
Yes.
Yes. What was the writ petition about?
If I may.
May I begin, my lord, for a minute? The case begins, my lord.
Who?
By a direct.
Just a moment. What is the function of this village council in a village?
In fact, I'll explain here.
This is a democratic.
Yeah.
This is a democratic institution.
Institution. In fact,
And
this is according to the 73rd Amendment,
no.
where we are exempted. Nagaland is exempted because of our customary practices. And because we are exempted in terms of 73rd Amendment, we have our own procedure, which is this particular thing where village is the most important unit.
You want the petitioners to be members of the village council or the respondents to be a member of the village council?
The respondents.
The private respondents want this matter.
No. According to his submission, both the parties are ready for a fresh election.
No, madam.
Mr. Joe, or you are not?
He can say so many things. I don't want to.
File an appeal, my lord.
That's why let us go into the facts
All right.
without interruption.
All right.
I start with page 91. And before coming to 91, the village council was to be dissolved by the end of March, 30th March. The tenure is 5 years. Just before the tenure, notifications were issued on 18th March, stating that the fresh election should be conducted before 30th of March.
Fresh election should be conducted.
Yes, before 30th of March.
Who issues this election?
I will just.
Order? Now this election is held under whose supervision?
In fact, as I had mentioned to your lordships here,
yes,
it's a slightly different setup, very peaceful setup in the sense they all sit. There's nothing like ballot box.
No. There is no supervision by any authority.
In fact, all what they do there is they give a list of the names. All the supporters' names are there and whom they want to be elected. That is the list. That list is given to the GB. Once it goes to the GB in turn will send it to the government and the government will finally approve the list. Then it becomes final. The role of the GB is to collect all these things and pass it over.
Under which provision?
That is a customary practice everywhere, as far as Nagaland is concerned.
Customary practice?
Yes.
From where do we find this customary practice?
In fact, customary practice, as far as Nagaland is concerned,
yes,
we don't have a script. We go by word of mouth. We go by what is happening from one generation to another.
Now that customary practice has to be proved.
No, that is.
Do you admit that this is the customary practice?
No. Lordship, the customary practices is this, my lord, which has been admitted by all the parties involved in this case, in their pleadings. The case, my lord, can I, my lord? There's a deliberation amongst the village.
All right, since the appeal is...
Yes, my lord, that's why.
And anyway, Article 13 says customary practice, customary law. That has the force of law also. If we need to make a submission on that, I'll make it separately. Now coming to the genesis of this. on 23rd of March, this head GV collected the names, according to him, of a few persons who, according to him, were selected by the members of the clan. Now, let us see that document. That document is at page 91.
Yes,
My lord has caused that matter.
yes.
I will carefully read this because the dispute starts from here. To ESC, forwarding letter for the formulation of new VCM based on the government order dated 19th March in regard to the formation of new VCM, I hereby present to you the name of the new VCM for the tenure from 2021 to 2026 for your kind necessary action. Now he has given 5 names.
What is this government order?
Government order is that, it's at page 88, that government order says the term of this council expires in 30th March. Therefore, we should hold elections, or these things before that. What's the page? 89, madam, the typed copy. Can I read this, madam? The second paragraph. Further, all recognized villages are hereby informed to form new village councils for the current tenure by selecting/electing their village council members of their respective village in accordance with the prevailing customary practices and usages as provided for the Nagaland Village Tribe Council Rule 79 and the Tribal Council Act 1978. In pursuance of Section 6A, such a village council duly formed under this Act shall continue for 5 years. Now, this is basically intimation of when this procedure would take place, and consequent to that, we come to page 91.
Okay.
Page 91. Now, in 91, what happens is, he says, I present to you the name of the VCM, directly self-appointed VCM, and he signs below. This document on the face of it is inadmissible. It does not even bear the signature of any of these persons who would have agreed for their appointment. Nobody's signature is there.
The agreement is required.
Yes, I'm coming to the next. Now what he does, I'm telling you. I'm sorry, sir, for telling you. So after this letter was sent, what happened, I shall explain later. Then he became wise, because the Home Commissioner who has filed an affidavit here said he only sent this letter, nothing more. Now kindly see the next page. Page 92, 93.
Which is the provision which requires the agreement of the chosen members?
Section 4.
Huh?
Section 4.
Section 4. Let us read the agreement part. We have read section 4. We could not find any such agreement.
Village council shall consist of members chosen by villagers in accordance with prevailing customary practices and usages, the same being approved by the state government.
Same being approved by the government. But,
Yes.
but where is the consent of the chosen members is required, that he gives his consent to be a member?
The word used is, a council shall consist of members chosen by the villagers.
Villagers has to choose.
Yes, that's the point.
But you, earlier, you were saying that the consent of the members chosen is required.
No, in fact, I will, maybe my thing will not clarify it. What exactly happens is, they choose the members, the villagers choose the members.
Choose the members.
And once they choose the members, they append their signatures and give the list to the GB. Otherwise, it's not that the GB can write
No,
anything.
that, from where do you find that procedure?
Which one?
From where do you find that procedure prescribed?
That is a customary practice, and that practice is not in dispute with them. They are also agreeing to it.
We are not at all well acquainted with the customary practices. So anything you say will be customary practice, anything he says will be customary practice. Where is the yardstick to? Customary practice has to be proved.
Yeah,
Unless it is
I'm coming to
codified.
that. See, as far as
No, that's why initially I pointed out, this will be the difficult area.
No, let me clear my submission for a minute.
Yes.
Kindly bear with me.
We come from a different parts where customary practice is totally different.
Yeah. In fact, everything varies from place to place, from tribe to tribe. We have just been arguing
Yes.
this case even in the Supreme Court recently on this very issue.
Yes.
That they have asked us, what is the evidence? The evidence is when you don't have a script, it travels only by word of mouth, nothing else. So that is custom. If you see the origin of customary law, it originated in international law, and the father of customary law was Hugo Gracious. So they say by constant practice and usages, customary law is evolved. That is why under Article 13 of the Constitution, they say under the definition of the term law, customary law is also there.
Constant practice
Correct.
has to be proved.
Yeah, constant, and that has been proved.
He says that the constant practice is A.
No,
You say the constant practice is B.
Does he say there is no
Evidence
customary
is
practice?
required.
Let his statement be recorded. Does he say that there is some other customary practice? If he wants to say that, let it be recorded first.
Anyway, let us proceed. There is no prescribed procedure. Okay. Consent is also not required of the members chosen under the statute.
How do we choose?
Yes.
Now, if consent
How do
is,
we choose?
how do we choose? So
As-
there must
as-
be
as
some.
per the prevailing customary practices.
Correct. No, as far as choosing a member is concerned, nobody can be chosen unless there are names of persons who are choosing them. We don't have an autocratic system in a customary law where the GB says, these are the people, I am appointing them. So the statute itself specifically provides that they will be chosen by the villagers. So what is the way in which the villagers choose them? That is, they will say that, see, we want so-and-so. To the GB, these are our names, we raise our hands. Then the GB will forward the list given by them to the government. That is the procedure. There's no confusion. Then, my lord, kindly take note of page 93 to page 97. These are the different names forwarded by the different clans to the GB.
Page
This-
93.
93 to 97. This is a typed copy. Now, this document, incidentally, was not submitted to the government at that time. So once he knew that he is lacking documents, he introduces in the court for the first time document 98 to 102. 106. Now, what is the effect of this? He says
93 to
106. 93, actually 93. 93 to 97 are the typed copies. 98 to 106 are the so-called signed copies. Now I am coming to page 98. Because even if you kindly see, he says, as per the endorsement by Botsa Village Council for the reconstitution so-and-so, the village council in the reconstitution for the tenure, Rio Plan Basta, then he gives the names. He gives the names of 30 persons. Eh? Yeah, we'll say.
Who has given this name?
This has been introduced or manufactured by the GB for the first time in this court. But
Oh,
let us not worry about that.
same GB.
Yeah, the same GB. And this GB was disqualified also later. That's a different thing. That's why I read disqualification. Now, if you see these names, what he has done, he realized that from the record it turned out he has not got the signature of any of these persons. He has only sent a paper list. So in the High Court for the first time, he filed this list. Now let us have a clear look at this list. This list
See,
of 30 persons,
Botsa village consists of 6 clans.
correct.
Each member will send one representative,
Yeah.
one member. Now, chosen means what? There will be an election. There will be an election.
Actually, it is chosen by, it's not a pakka election, chosen by the
Now,
villagers.
one clan consists of how many population?
It varies. It varies.
Approximately.
In fact,
And it will be chosen by, of course, the adult members. Adult members, is not it? Suppose in a clan there are 100 adult members. If 60%, sorry, if 40% does not agree, then there has to be election.
I'll come to that. I'll come to that also. I'm making a note of all the queries. I'll make a note of that. Kindly come back, my lord.
So choose. We have to first understand. We have to clarify the chosen. How to choose?
In fact, choose means I like this man, I choose him. That's all.
Yes.
That is the customary. So there should be a record that he has chosen him. So
Yes.
for that record purposes, the person will put his signature on a list, and then it will be stated. Because if he doesn't do it, it means not democracy, it means autocracy.
Is there any rules made pursuant to this act? And under the rules made, if any, is there any procedure prescribed for choosing the members?
Everything revolves under the section itself.
Section
4.
itself, customary practice.
That is the thing. Then, my lord, kindly see this, page 119 for a minute.
We are running in. We are treading into a difficult.
Let us meander our course for some time.
Particularly, this court would not like to gloss over anything.
That's all right. We will go into it.
If we have to write
We
judgment,
want this honorable court to go into it, because what we have to actually go into it is just coming now.
before we reach to the XYZ,
Correct,
we
correct.
must understand
Correct.
ABC first.
Correct. So now,
Unless we are clear, we will not
Correct.
go into it.
Correct.
Customary practice,
Correct.
it's not that easy.
no, in fact, I just want to make one submission.
Yes.
Some people want to choose a particular person. Now, what is the evidence of choosing? There should be some evidence. The evidence of choosing is his name will be there. And in that name, one group of people will decide, let us choose this man in the clan. So, corroborative evidence that they have chosen in the form of a written document, they just mention the names for clarity's sake. We have chosen this person.
See, in the absence of any procedure prescribed, the normal understanding of choosing would be, because this choosing will have to be made by the entire population of the clan, is not it? And may not be the entire population of the clan, but at least the adult members of the clan. They have to agree to a particular
Correct,
person.
correct.
If there is disagreement, so naturally there has to be election, is not it?
I'll come to the document which is related to exactly
So-
this query.
So for that purpose, the person chosen by the majority of the clan will have to be the representative of that clan.
Yeah.
Correct? For that, it is essential to know this both what is the adult population of Botsa village, and consequently
I am
each-
coming to that after 4 or 5 pages. If I could proceed here,
Yes.
I'll come to that and I'll clarify that.
and
If your lordship wants me to come straight, please come to page 119. I thought I will give a,
okay 119.
yes, please, 119.
Miss Sukri,
Page
what
119.
is the population of it's in the record.
Yeah, kindly see,
Population of Botsa village.
kindly see what is written here for a minute.
Yes, page number 119.
Yes, submission of verification report regarding clan representation of Botsa village for selection of BCMs. With reference to the subject cited above and to your letter number such and such regarding clan representation of Botsa village for selection of BCMs, I have the honor to state that the undersigned issued a circular on 3rd April for verification of clan representation of Botsa village for selection of BCMs to be held on 6th April 2021. I would like to state the following verification report as: the Rio clan has 63 number of bona fide heads of tax-paying households. There are 31 members present, and all were in favor of Sri Sutan Rio, who was the lone candidate. Next, the Shia clan has 24 numbers of bona fide heads of tax-paying households. There were 11 members present, and all were in favor of so-and-so. The Kensi clan has 53 numbers of bona fide bases of tax-paying households. There were 24 members present, and all were in favor of so-and-so, who was the lone candidate. The Zimu clan has 37 number of bona fide heads of tax-paying households. There were 15 numbers present, and all were in favor of so-and-so. The Sanchu clan has 21 number of bona fide tax-paying households. There were 6 members present, and all were in favor of so-and-so. The Ziru clan has 1 number of bona fide heads of tax-paying households. Three so-and-so.
This is a letter by an extra assistant commissioner.
Correct.
Is it factually correct?
See, if we say nothing,
this is not a
nothing
public
is there.
record.
These are documents not in dispute. These are the documents submitted to him, and I will take this court to those very documents. Please let me continue from the page I said.
And I wanted to ask you at the beginning, but since we proceeded, now under which provision this GV sends the list to the government?
This is again a practice.
Yeah.
Under
It
section
is again a
4.
practice.
Yes,
Because reading everything is done under section 4.
correct. Who is the GB? GB is supposed to be the head.
It does not, yes. The
So-
section 4 does not say that the GV should forward the letter.
Section 4 will not say A to Z of what he or her has to do. They give the rudimentary structure of the selection process, and then to give uniformity to it, they have one person who will push it ahead. That person incidentally happens to be the GB. So this is the practice which has been going on. And as far as this practice is concerned, in the entire state of Nagaland, there is no second opinion about it. That's a position. And if that is the position, that is the position. Now kindly come, my lord, to... Now, if you want corroborative evidence of this, I have got. But if you want, then I will be jumping from page to page. You could just bear with me. If you want me to go there, I will go straight away. There's
Yes.
no... Now, my lord, coming back to, I think I was on page 98. My lord has got that, my lord? Is 98? Now, when we say chosen by the villagers, by the members, this is the indication of chosen. These number of persons chose. What is interesting is these numbers which have been written here,
98 is of the Rio clan,
Rio clan.
one of the clan.
Yeah, one of it. Like that for each clan there is. I'll come to each page. Now, if you go to Rio clan, one name is given here. Next to that name, there will be a signature. Now, here, what they have done, the same person has written this entire list of 30. Please have a look at it. Kindly have a look at it. The same person has written, though he tried to hoodwink the authority by introducing a list supported to have the signature of everybody, this is what he sent. Like this, like this. Kindly see the next page, madam. Kindly bear with me. Let me just about 5-6 pages. Then I'll come back to what.
Okay, all right. No, there are no signatures of any of the members.
Not even date.
Okay, all right. Okay, then?
Now this comes up to
Yes.
104. In 105, kindly see 105. There are some signatures.
You mean to say that the name sent by this GB
Yes.
was not chosen?
Yes, that's exactly the case.
Was not chosen
Yes. That is the point.
because the person who the GB is showing that this person was chosen by these persons of the village, they did not put their signatures.
He did not even, in the first place, send this list. This list was introduced in this High Court. But even if we go without much dispute, even here, what he forgot was, he thought it will be passed on as everybody's signature. Just apparent look at it shows the same person has written everything. So this is a document which is an attempt to change the legal identity of his case. So our case is, he sent a piece of paper and the Home Commissioner, who is in receipt of all this, has specifically filed an affidavit in this court stating that he sent only this first paper. All these annexures are his introductions. I am going one step ahead, presuming that he sent these annexures for the sake of arguments. Even then, they are not admissible in law because these names have been written by a single person, undated, and does not contain the signature of everybody. Now let us see how the other list is.
Yes, yes.
Yes. Now, my lord.
Other list means your list.
No, I am not my list. There are
No,
two parties.
Joe, see, Joe's list.
Those persons whom we approve.
Yes, whom
Yes.
you want. Yes,
Yes.
let us see that list.
So now kindly see.
And let us see the customary practice.
Kindly see page 172.
172.
172. 172.
Yes.
Just a minute.
Earlier list was dated.
172.
Just a moment. Earlier list was dated.
Earlier.
No date.
No date, man. No date, undated.
And your list is dated?
I'm coming to my list, my lord. Kindly come to page 172.
172.
Now,
Yes.
this is my grievance. I may have to read this. Request not to entertain unmandated list of BCMs for Botsa village being forwarded by the head GB, whose own case is pending disqualification. Forget it. With due respect, we so and so. Sir, Botsa village has a prevailing customary practice of choosing BCMs clan-wise. As such, our respective clans have chosen us to be the BCMs for the Botsa Village Council. A copy of our mandated selection enclosed. Our respective clans have duly given a copy of our selection as BCMs to the head GB of Botsa Village for further necessary formalities with the government. However, against all ethics and followed practices, to our utter surprise, the head GB of Botsa Village has, rather than forwarding our mandated list of BCMs, forwarded an unmandated list of BCMs according to his own whims and fancies. Mention may be made that the head GB of Botsa village is a GB of so-and-so, is a government servant, all those disqualifications. We therefore request your authority to kindly take cognizance of the matter and do reject the unmandated list of BCMs being forwarded by the head GB of Botsa village and do approve our mandated selections as VCM by our respective clans in the larger interest of Botsa village in particular and for democracy to prevail in general. Now, these people have sent a representation. Now, next page is page 173.
Who are these people?
These are the private persons.
Private person.
Yeah,
For example,
yeah,
Kehujelio Rio.
yeah.
Can he represent the entire Rio clan?
Clan. Rio clan.
Is he authorized by the entire Rio clan to represent? on their behalf?
He gets his authority by the effect of choosing him by the Rio clan elders. It is not that he is given any power of attorney, we allow you. No. It is a democratic process.
Oh, he's, at serial number 1, he has been chosen as a member of the
Yes.
village council
Yes.
by Rio clan.
Yes.
Where is that choosing part?
One.
Where is that choosing part?
Kindly see 180, my lord.
180.
There. Typed copy. Yeah. The typed copy is at page 182.
Yes, 182.
Rio so-and-so Botsa village BCM, Collectorate New Garuka, 14th March 2021.
No, this is in the vernacular.
Translated copy is here at page 183.
183.
Yeah. May I read it, madam?
Yes.
The resident of Rio clan at Botsa held its meeting on 14th March 2021 and selected Mr. Cosilo Rio to be a village council member. The members who are agreed to let Mr. be a BCM member convey our names and signatures. Therefore, you are asked to forward our BCM to the government. So this is a resolution which they pass.
This is by how many person?
34. Is that which page? This.
Rio clan consists of only 34 person.
Elders.
Huh?
60 are there.
60 are there.
Yeah.
Then where are the signature of others?
How are the signatures?
Where are the signature of others?
This is the entire list. This what we have given. Where are the signatures of others? I'm coming to that. Where is it? 180. Kindly see. People who have participated, people who have chosen him unanimously.
I think this is a subject matter of a suit to be filed.
No, madam. With respect, I kindly.
Now, see, you say Rio clan consists of 60 adult members. 60 adult members.
Household.
60 household.
Household means the elder man.
Where is the proof?
This is a customary practice.
But
And as far as customary practice is concerned, this practice is not in dispute, nor can the court direct that this is not a customary practice. Because we don't have a script and the tradition follows from one generation to another, and this is not in dispute either by me or by him. He also has followed the same procedure. The entire elections in Nagaland takes place only by this process.
How this writ court, sitting under 226, would record a finding that Rio village has a 60 household?
In fact, the writ court only interfered in this matter. If they did not have the jurisdiction, the writ court could not have interfered in the findings of the government. Having interfered with this, now it cannot be said that you don't have the right. The right was exercised by them. That right was accepted by the High Court. Or suppose this honorable court comes to the conclusion the single judge had no jurisdiction to entertain it. That is the end of the matter. We have crossed that. We have crossed that stage. I understand there are many things in this which are worrying this honorable court. But I will slowly take you through the garden path to the final area. Then your lordship can make a choice. Bear with me.
So, what this court is trying to say is, don't force this bench to exercise the jurisdiction like the learned single judge has exercised it without asking these questions, which this bench is asking to the learned advocate.
I am not saying
Yes.
that the questions are unwarranted, not at all.
Yes.
Every question when you ask, I remember I did a case about 16 years back in Gauhati before a learned judge who later became Chief Justice of India. He asked me a few questions I could not answer. Then he told me, Mr. Balgopal, I think you are feeling uncomfortable, so I will not ask any questions. So then I told him, please don't do that. If I don't know the answer, it's a separate thing. But please ask the questions. Because only when you ask the questions, we will also know which is the path in which we are traversing. So as far as the right of asking the questions, that is inherent in this court. In fact, this court should ask difficult questions. And we are here to answer in accordance with law to the extent possible. And if there is any gray area also, we'll bring it to this honorable court's notice so that without violating any procedure, we can come to a conclusion. Please, ma'am.
And we may tell you that we have a lot many questions which we have not yet asked you.
That's okay. That's okay. That's okay.
By looking at this, when you had initially pointed out section 4, then this court knew that there will be a host of questions.
No, let it be a host of questions. That is what I am also asking as far as this petition is concerned. Let us go by section 4. Who has violated section 4? Section 4 has been violated by this particular GB, who, without a person being chosen by the villagers, on his own, unilaterally, declared 5 names without signature, without dates, and sent it to the government, while the proper list given to him was rejected.
Problem in this case is the legislation itself. The legislation itself, Village Council Act. There are too many loopholes here. As a learned advocate general, I think you will appreciate this. This has to be fine-tuned.
I agree. As far as, in fact, I just mentioned,
it's not free from difficulty.
Yesterday we had a consultative tribal meeting here in Delhi, in Kohima. I was also a party to it. So specifically, this act came into question for the reason, if you see this act and see the number of amendments from 78 onwards, amendment is just put as 2-page. There is no inclusion of amendment in the Parent Act. So that those who read the Parent Act will not know the amendment. So as this court has rightly pointed out, a synthesis of all the amendments are going to be incorporated in this shortly. This is a statement made by the concerned officer also yesterday. I also pointed out it's very difficult to understand this act. So they said this is because each time an amendment is put, it is kept separately. There is no incorporation of that amendment. Generally, we will write italics or in star that introduced by amendment such and such, then we can look below. There are some difficulties as far as this is concerned, but we will definitely address that question. Now, my lord.
Yes. Then what happened?
Yeah. Now what happens is,
then there are other 4 clans.
I'm coming to that.
5 clans.
I'm coming to that.
Similar questions.
Similar question. Now kindly see, I have started with page 174. We started with 174. 174. This is already read. 174, madam?
Yes.
Now in page 174, we have the name, we have the signature. All. We also have the date on top, 29th March 2021, such and such, such and such. So the complete thing has the signature, the date. So this is being forwarded. Then the typed version is in the next page, 22 persons.
Type copy is at page
176.
176.
I've calculated the number, etc.
This is again in the local dialect.
Now come to page 177, which is the resolution. That's important. May I read it? The residents of Zimmu clan at Botsa had its meeting on 29th March and selected Mr. So-and-so to be our village council member. The members who are agreed to let Mr. Kalil be our VCM convey our names and signatures. Therefore, you are asked to forward our VCM to the government. Now come to the next page. Page 179. Translation is? The translation is at page 183. Kindly see 183. The residents, we have already read this, Rio clan.
Yes.
Right. Now, the same process is here. Everywhere, every place, signature is there. Now, let me come to the next one. Page 183 is the resolution. 184. 184 is Botsa village Sanchu clan. Yeah. 1 minute, please. This has the entire signature. This has the date. And the typed copy is this. The next one. Page 192. Again, names and signatures. Typed copies on the next page. Kindly see page 197. Some have even affixed their thumb impression on this. Lordship, you got this, Madam?
Yes.
197.
Yes.
Top, it is there. Yeah, that is it. That's the page I have. Then, my lord, see page 198. This is
Yes.
important. Here, the HGB, before going into this document, page 197, 198, the HGB had included a particular Rio in the list of signatories, list of members. That particular Rio has filed an affidavit that I have got nothing to do with this. I'm not a party to this. And the affidavit is on record. Kindly read this. I so-and-so, I am a bona fide citizen. 3, deponent through reliable sources has come to know that Sri so-and-so Rio, then GB, and so-and-so Sali, the then head GB, have submitted an endorsement list of Rio clan of village purported to be selected by Rio clan, where it has been shown that the deponent was present in the village and supported the candidate for the tenure, whereas that fact is neither true or correct. Endorsement so made is nothing but perversion of truth against the dependent, etc. So they not only wrote names, they did not take their signature, and some of them who came to know of it have even filed affidavits that we have got nothing to do with it. So we have before this honorable court 2 lists. One list is a simple list without signatures, without date, and all these things are called endorsements. You write the name, you sign, you endorse the candidate. So you have the 2 lists before the court. Next, what happens? The meeting takes place on 6th May. Before that, an instruction is given on 3rd May 2021. 3rd May. Saying you hold the verification of these members on 6th May. Now, there is a dispute between 2 parties. Once the dispute starts, Section 20 will be applicable. The competent authority to look into the dispute is the government. The decision of the government is final. It is not that the government overlooked all this and went ahead. When 2 lists came of conflicting views, then the government was constrained in these circumstances to look into this matter in terms of Section 20 I've read section 20. If you want, I can read it again. Section 20. Kindly see. When a dispute arises as to the selection of any member of a village council, the matter shall be referred to the state government, whose decision thereon shall be final. So it is not that the government unwarrantedly put their finger into it. We would not have put anything if there was a single list supported by all the documents. Or now, since a dispute has been created that the head GB did not send the list, so they were constrained, limited only to this, to check the authenticity. So both the parties were called on that date. Now, on 6th May 2021, it so transpired that the GB who gave the 5 numbers, he didn't have much candidates in his hand. And in the end, in the evening, he wrote a letter to the government saying there was a commotion at the time of election because this village, some persons were interested in renaming the village. There was a protest on that. Proper law and order has not been maintained. Therefore, we are withdrawing from the verification. It's very important. That is there at page, my lord, 115. Kindly see. One 115. My lord has got it, my lord. 115. May I read it now? 115 is there?
Yes.
I'll read it. Withdrawal from verification. As per your order dated 30th April 2021 for verification process of the household head for the formation of BCM, all the clan of Botsa has come to your office. This word is very important. We have come to your office for the same. Next. However, there is an endorsement of the former village council in the process, creating chaos and undesirable situation. Sir, as you are aware, it is clearly mentioned in the Village Council Act of the government that every village council shall have powers to deal with internal administration function. To such, the aforementioned involvement in the process is direct challenge and infringement of the Botsa village powers, which is unlawful and violation of the Act. Administration has failed to deliver justice to the matter. As such, Botsa village cases shall withdraw from the verification and appeal to the administration to fix another date. So his grievance here is this. Which is that letter by
No document contains any date. No document contains any date.
Yeah.
Now let us see the order passed by the government.
No, just 1 minute. Please bear with me. After this 6th May letter is passed,
List sent by his GV is undated. List sent by your GV, means Joe's GV is undated.
in fact, these typed copies, in these typed, we have the dates of the letters in the affidavit filed by the government, and that is also not in this. I will read that. Even I had the problem. I was thinking, how is it that no date is here? I was under total confusion. I apologize for that. I'll read out.
Let us see the order passed by the government.
Yeah. I'll just show the affidavit.
Order must be in favor of the private the
Yes,
respondents.
but before I go into
And
that,
the petitioner had challenged that.
before I go into that, I have necessarily to see the next 2 situations of this very person. Here he says, I have withdrawn. So there is no question as far as his participation is concerned. He keeps quiet.
We would like to see your decision.
Pardon?
We would like to see your decision.
Yeah, we will give our decision also. Then, on 17th of the same month, that's the next page, at 117. Kindly see this complaint, it metamorphoses into something else. With due respect, may I read it, my lord? With due respect, we understand on behalf of the general public, we would like to state a few lines for your information, necessary action. As per the order of the E. Botsa, all household heads of Botsa were informed to report to the EAC office for verification process for formation of the VCM. However, on the said date, the people of Kohima deliberately arrived. Now, these are things which were never there. Blocked entry of genuine household heads who were in favor of Botsa nomenclature. Their participation was disallowed, and also 4 of the Botsa members were brutally beaten up by so-and-so. Sir, the overt brutality and illegitimate infringement by the people of Kohima is also direct challenge to the law and order. So the matter has been vehemently written. So you might have received the reports of the verification. However, as clarified, the people of Botsa shall never accept the said reports which were done through intimidation and illegitimate means. He is calling the government illegitimate. We look forward to your personal and examination. It's another day for verification. Now, what is there in this letter is, he has introduced things like violence, injury of 4 persons, prevention of the persons from entering for the purpose of voting, which was not there on the date on which he issued this first letter dated such and such. Now kindly see after this. I'll come to the affidavit. No, in his writ petition, he has improved it. Just a minute. Page 65. Huh? Para 11, page 65. This is the third expression coming in the form of an affidavit.
Which affidavit?
I'm sorry, in the petition filed by them. That's right, writ petition. Now, para 11, page 65. May I read?
Which one you are referring to?
I'm referring to page 65
Writ
of
appeal.
of the paper book and para 11. This is actually of the writ petition.
Okay.
I'm sorry, madam.
65. Yes.
That as directed by letter dated 3/5 and suspecting no foul play, the villagers went to the office of Extra Assistant Commissioner on 6th May. To their shock and surprise, now here is a further improvement. There are about 150 to 200 villagers outside the office. They wanted to prevent those who did not want to change the name from entering such and such or have their candidates selected as village council members. This led to a clash in the process. 4 persons from Botsa village who belong to the group, not wanting the change, got beaten. About 30 members of the rear clan who were directed by the Extra Assistant Commission to appear before managed to enter the office, and their leader, petition number 3, told the EAC not to conduct any proceedings as it would not be fair, proper and just because of the situation created by them. The Extra also agreed that the Rio clan left, while the Seal clan who were directed to appear with their leader. Similarly, all the others appeared. It was subsequently learned that at the instant of they gathered outside, some Bosa villagers were in favor of the change, etc., etc., etc. So this is the third expression of a letter which only said there was a commotion. He doesn't speak of beating. And he speaks of 4 members of theirs were beaten. Their names have never been revealed by this GB at any stage. There is no medical certificate to explain this. Just a false pleading to prejudice the mind of the adjudicating authority. This shows his unfairness. He says something on 6th May. He improves upon it drastically on 17th May. And then when it comes to filing of the petition, in that he speaks of 200 villagers came from here, there, but the fact is he did not participate in the verification. This is the fact. He didn't have the members, he didn't have the document, he had only the single page at that time. So he wanted to escape from this proceedings. This is the whole game. The other side. Now, my lord, the fact that they did not participate is not an allegation. It is an accepted fact. I'll just point that out in a minute. Before there's a particular aberrament in one of these affidavits where he says that we did not participate because of this. I got it, page 211. Sorry for the time I'm taking.
Yes,
After 26th of March, the names of the private...
209.
211, sorry. After 26 March 2021, the names of the private respondents were sought to be submitted to the respondent number 10 by some villagers, but he refused to accept the same because by then he had already submitted the names of new village councils as per the directions given to him by the letter dated 19th March 2021. So he says, acceptance. I didn't submit that letter. He had no business, no authority to do it. It's the most undemocratic method, be it customary law, conventional law, or any law, that somebody is saying, I want so-and-so, I'm giving you a list. He says, I won't accept it. My list has gone. My list has gone on 23rd, which means whatever fake list he gave on 23rd, they will automatically be accepted according to him. And as far as those who have signed, who have taken the pains to put everything, theirs will not be. I also want to point it out that initially the period fixed for submitting all these lists, completing the formality, was 30th of March. Kindly see. 30th of March was the date in which all this procedure had to be completed. But the government extended that further on 30th of March itself to April. So I have given, these people have given the letter to the government on 5th of April, well within time. He had no jurisdiction, whatever be the law, to reject this and to forward a list which does not have the sanction, sanctity, or response from the persons whose names are supposed to have been given. This is nothing but a mockery of every law. This is permitting a huge fraud on a process by which villagers select their leaders. This is very unfortunate. This is what he has done. Then, my lord, kindly see page 137. That is the affidavit of the Home Commissioner. one thing is very clear now. His list, he disowned his list. He backed out of his list. And he said that I am withdrawing. While the letter issued to them on 18th of March, which I'll read out again, says that under no circumstances this will be adjourned. And you will get no further time, unless, of course, it is extended. Of course, you can always challenge any order on valid reasons.
Let us see how the government has decided.
I'll just come to that. Kindly see, for that purpose only, the affidavit of the Home Commission. That gives the gist, and then I'll come to the orders.
See,
I get your point.
this,
I'll come to those communications by which how the EEC sent the letter, from there, where all it went, because there was a doubt, even at the time of admission, how can the EEC allow this? How can you give finality?
what you are pointing out has been referred to in the decision of the government.
My lord?
What you are pointing out now
Yes.
has
This
been
is-
referred to in the order of the government.
This is an affidavit given by the Home Commissioner,
Ah.
giving briefly exactly what happened in the election, pursuant to which the government came into the picture, the government called the contesting parties, and the limited role of the government was only to see the authenticity of the documents.
State government means who? The Home Commissioner? Who will decide under Section 20?
In fact, it is the Home Department which ultimately decides
Okay.
on behalf of the government. But before that, it will go from the concerned officer to the EEC, to the Deputy Commissioner, and one more person. Then the Home Commissioner conveys the approval of the government. Full thing is done in a process because.
No, when there is a dispute,
Right,
then the state government has to decide under Section 20.
correct.
Which is the authority of the state government to decide?
In fact, as far as the dispute is concerned, it proceeds from the assistant EAC to the DC to another ADC or something like that, then the commissioner, then ultimately.
Which commissioner?
Commissioner of Nagaland. Then from there, it goes to the Home Commissioner.
Yes.
And the Home Commissioner writes a communication saying, this is done with the approval of the government. I will read out those documents. There's no procedure we have violated. And that is a procedure we have always complied with, and there is no question on any violation. It is not that, and Section 22, if you were kindly to see, have a look
So
at it.
state government, according to you, state government referred to in Section 20 is a multi-body.
Correct, from layer
Huh?
to layer. That is clarified in Section 22. Please see Section 22. You got that?
No, Section 22 is a control of the village council.
Yeah, I'm just saying that. Subject to the general
The sort
superintendent of state government.
issue in this case is there is a dispute regarding the membership.
That's
So
right.
the section, there is a dispute. There is a dispute of the membership.
Correct,
Who are the members? There are
Correct.
two sets of members.
correct,
So in case of a dispute, government has to decide
correct,
as per Section 20.
correct.
So Section 22 is not relevant. Section 22 will come into play when the village council is constituted
We will
and
just
the
read.
government will have a control.
We will just read for a minute. Subject to the general superintendent of state government, the deputy commissioner, so-and-so commissioner, so-and-so shall have control over all village councils within his jurisdiction.
You will have control when
So-
the village
So
council is constituted.
therefore, when the dispute arose and the matter was handed over just to find out the authenticity of these documents, after that report is submitted, it goes through different layers up to the competent authority, who is the Home Commissioner, who decides all these facts. I'll read out his letter also. So that is the person who does it, and that's the procedure which we follow.
Various orders issued by some authority of the state, that's an administrative order or internal communication, something like that. But what is relevant in the instant case is the state government has to pass an order which is statutory in nature.
Yeah, it is said
Correct?
here,
So now, dispute has arisen regarding the membership of the village council. So the state government has to resolve it. How have you resolved it? That is relevant. And that order must have been challenged by the petitioner. Correct?
That's it.
Now, order cannot be justified by an affidavit, that letter written by some authority.
I'll bring out that letter. This is
Yes.
unfortunately, my file is little jumbled up. Page 122.
Yes.
I'm sorry, my lord, my file is slightly jumbled up. Page 122, 8th June 2021. May I read it?
Yes.
Approval of newly elected members in respect of Kohima district, such and such date. Inviting reference to the subject matter, I am directed to convey herewith the approval of the government of Nagaland on the proposal for the constitution of newly endorsed village council members. The approval list of VCMs is enclosed as an extra for the favor of your necessary action. This is the order. Next page
It is
123.
of Kohima district.
Next page 123. At 06, where it's put Botsa,
Okay.
they have given the 6 names.
Ah.
So like that, they have given for all the other villages where the election took place, not just for us.
Okay, this was under challenge in
Yes.
the writ petition.
Yes. We have just filed it like you
This
rightly
approval,
asked.
this approval is given under which provision? Approval is given under section 4 itself, huh?
Yeah. Approval is given because of 2 sections.
The same being approved by the state
Yeah,
government.
yeah.
All right.
One is when a dispute arises against section 20 as to the election of any member, matter shall be referred to the state government, whose decision thereof shall be final. So it is the state government and the home commissioner is conveying the approval of the government, saying that this is the portion. So it is strict compliance of section 20. And this is how all the villages, not just for us.
Page 122 is an order passed under section 20. I don't think.
Though the sections, etc., may not have been mentioned, this is the authority. The gist of it is the order, the reference was made in this case to the government by the party concerned who is aggrieved. He made the reference saying that I am being overlooked. They have made a lot of problems for me.
After this order was passed.
Not after this order was passed.
After this order was passed.
He first on 6th May, they simply collected this and sent their recommendation. There is nothing else. He gives the details. These are the clan members. These are this. He sends it. So on that day, he raises a dispute on 6th May, stating that, see, I have not participated or I have withdrawn from the process. Subsequently, on 2 occasions, which I have mentioned, he changes his stand, trying to make it as though he was prevented. So a dispute arose. Therefore, and there was another letter written by the private parties on 5th of April, which I have just read out, stating that the village GP did not consider our application. Without considering our application, he has considered their application, and therefore we are going to be kept out if this is going to be the attitude. So 2 contesting parties gave their 2 different views, and therefore statutorily the government has a duty bound by an obligation to decide this matter. Government has no business to find out whether this customary law has been violated or that customary law is violated. That is completely in the realm of the villagers. Once they do it, if they seek, they can only look into this, whether the authenticity of the documents, they don't do any election selection on choosing anybody. They have the same list before them. They will see from this whether the list bears has authenticity, it has been signed by the correct persons, and they are present. Give one more step forward. Suppose, I was just reading this yesterday, 35 members have signed. I can demonstrate it numerically also. And say this private complainant, he responded, he has got a signature of 35 persons and he gives it for verification to the EAC. The EAC does not say that there are 35 members in this, so I approve. No. He goes to find out how many of them who have signed are present before him. And in many such cases, you will find normally 2 or 3 persons may not have come. So proportionately, in his verification report, the number would be apportioned depending upon when he verifies the authenticity of the people who are before him. So in this light, it is the government and nobody else, according to the statute. This book itself, which we say is an act of the legislature, and this gives power to the government to decide, and approval of the government has been conveyed to the concerned department by the Home Commission. So this is one set of it. Can I now just come for a minute, my lord? Can I have some water? Sorry. The larger question now is, I thought I will read the Home Commissioner's affidavit also, but since I've shown the order as to how the decision has been taken, if necessary, I will read it, that's no problem. Now the short question here is, the fact that this is a procedure which is followed throughout, there's no dispute on that. And in an election for village council member, how far is it correct for a person not to comply with Section 4 and agitate his grievance? I was being asked Section 4. Now I will read Section 4 again. Bear with me for a minute, my lord. I'm sorry, I'm reading it again and again. Our case, as your lordships have understood, this as a primary significance.
Yes.
A village council shall consist of members chosen by villagers in accordance with prevailing customary practice and usage, the same being approved by the state government, etc. So as this honorable court has initially pointed out and stuck to it, that it is chosen by villagers. Where has this list been chosen by the villagers? The first point. Instead of asking the government, which is the procedure you followed, let us take his case. He does not bother about who are the clans. None of these members were chosen. Section 4, on which they are heavily relying upon, has been violated with impunity blatantly by them. Just one self-styled man gives 5 names and asks them, appoint them. And when the correct names are given, where he is duty-bound to consider and forward, he keeps that away only for the purpose. They selected 5 of his. They should get appointed. So where is the question of dispute on Section 4 as far as the dispute is here? He has not complied with Section 4. If he has not complied with Section 4, all actions taken by him goes. That is the short point in this case. He has not done it. And the larger question which I was bringing to your Lordship's notice was that this is a clear case of fraud. You stand up. Some people living in the villages may not know the niceties of law, but they all know one law: fair play and equity, natural justice. This is somewhere in everything. Now, you just bring from somewhere your pocket, give 5 names, and you are not able to sell those names. And when you fail to sell those names, you create a confusion saying that at that time there was a commotion, so I am withdrawing from this. Because even the judgment speaks of 2 lists or 1 list or whatever it is. That is immaterial, because a list which can be admitted in evidence is those lists which are approved by the villagers. His list, in spite of the fabricated document which he has filed, does not clothe it with any tinge of legality. This is nothing, just a piece of paper. And with that piece of paper, he is holding on to the elections, for which the village will suffer. I can understand if there are serious questions of things which are a little confusing, etc. But he has no locus. Section 4 has been violated by him. He has to explain how he is covered under Section 4. Once he is not covered under Section 4, that's the end of his case. There's no further thing to be gone into. Just page 138, only one paragraph.
Yes.
This was the Home Commissioner. He says, may I read it, my lord?
Yes.
138, para 9.
Yes.
That with regard to the statement made in para 7 of the petition, the answering deponent states, head GB so-and-so, by letter dated, submitted 5 names of village council members in formation of a new Botsa village for the tenure 2026 to the Assistant Commissioner Bosa, full stop. However, it is denied that head GB had also submitted the letters of endorsement by the persons representing the households in each clan in favor of the person selected by way of resolution. The said document in the form of resolution was never brought to the notice. This is senior officer like the Home Commissioner, he is stating. So therefore, my lord, when these things have admittedly not been brought, I went one step further. I said, okay, let us, for the sake of arguments, consider that. Even when you go into that document, it again turns out that there is nothing in these documents. They are not, he tried to hoodwink, but he is not so clever. If he was clever, he would have done many more things. He couldn't do it. Even the fabrication he did fell short of statutory requirements. And he is the person who is going to decide that that election should go, because I managed to scuttle that election. Those who are lawfully elected, you can all go wherever you want. I'll have the election redone. This is not fair. This is a complete insult to the process. The Lordship will kindly see. And as far as Section 20 is concerned,
Yes.
Section 20 is concerned, There are judgments of this court. Even last month, there's a judgment which I will point out. Let's see the paragraph. Which is the paragraph I should read? Who will give me judgment? Very well. They've given judgment of the court.
What is this judgment?
This one, no? This is a judgment of last month, my lord. And para 12 of this judgment, my lord. The color of para 12. My lord has been given the judgment. You agree?
Yes.
In the present case, the state government, as can be seen, has approved the updated list and also the disqualification of 12 members to the village council out of 18 persons who were earlier selected and approved. Therefore, it is to be seen the provisions of 16, 17, 20, apart from section 20, has been adhered to by the respondent authorities. In view of, I do not find it necessary to refer the case. Also, it is found to be different from the present case. This court in this case has observed that the role of the state government under section 16 of the BC Act should not be usurped by the court, whereas in the present case, the state governments have already taken the decision which is found to be sustainable, and the question of usurping the role of state government will not arise. So the significance of section 20, that unless there is that type of material, nothing is invincible in law. Even if there is a statutory bar, you can always find a way to challenge that. But here, what is this locus? Can a person who has indulged in these malpractices having a big laugh? What is the villagers who have some respect for truth, a good respect for truth, are they to believe that if you go through an honest procedure, you will be thrown out, and one person who's playing hanky-panky with the law, he will be again given a chance? So that position of section 4, he has to establish clear evidence that he sent a piece of paper.
Yes. Yes.
Ma'am, these are some of the brief facts. I've tried to make it as brief as possible. I'll just have a look at the judgment. The judgment, impugned judgment.
There is a rule also, no? Rule frame, Nagaland Village and Tribal Council Rule 79. Under that rules, is there no any, no elaboration, all right.
There are some shortcomings now they are trying to come and clear out. It's just by evolution, it may take a little time.
Where is the list sent by this
Private respondent,
private respondents?
172.
172.
172, that first page deals with the complaint. That's very important.
172.
172 is the complaint. Thereafter, from 173 to 197. This is the list.
One 172 is by the chosen members. Where is that letter choosing these persons as a village council member?
Correct. So you will get it following that. 180. The Rio. Your Lordship wants the government list or what is there on record given by the parties?
By the department, no, this.
The government list, my lord,
Who?
is at page 123. After conducting all these, after giving the final approval.
No, that is the approval given by the government.
Correct.
To the list sent by the other side.
Correct.
Respondents 7 to 12, I think. Is not it?
Here, no. 1, 2. Petitioners, we were the petitioners, 17 of us altogether, my lord. 3 each from every clan has come before this honorable court, including 2 GBs.
I'm giving
the village council members.
Now, my lord.
See, your members is at page 91. Correct?
Yes, my lord, yes.
Then where is the other side's member sent?
That is starting from here.
You had pointed out this earlier.
Correct.
Page 172.
172 is my complaint.
172 is a letter by already chosen members.
172.
Chosen members, isn't it?
He said, we would like to approach your authority for favor of the necessary remedial action as a prevailing customer. We therefore request your authority to kindly take cognizance of the matter and do reject the unmandated list of VCMs being forwarded. Thus, from each clan, one person has signed. And the actual explanation is given, which your lordship has just asked. This is in 180. And before 180, the resolutions are at page 177 and 178. 5 resolutions are there. This is for one clan. Then, my lord.
Okay.
In fact, the type
Page
number.
Page 172 is dated.
My lord?
Page 172 is dated.
172 is dated 5/4, 5th April. Right at the bottom, fortunately, they have put a date.
One of the council members was. This is not a date actually.
No, in fact, I will show the date from the affidavit, my lord. There it's very clearly mentioned. There's no dispute on the date.
But why this?
I know, I think maybe at the time of this was not very fit. Should have been. Even I was quite confused reading this. So I was presuming these are. Then I found it from the affidavit. I'll make the corrections for your lordship by a piece of which I'll place on record. Lordship has got 180, then again 183.
And, just a moment. And page 122 is the approval,
Yeah.
is not it?
Pardon?
Page 122 is the approval
Yes,
given
yes,
by
yes. There's the government approval for Botsa village.
8th June.
Correct. Then this goes on, my lord. Till page,
Is there any decision by the government under section 20?
my lord?
Page 122 has been set aside by the learned single judge,
Yes.
correct? Then directed a re-election, reconstitution of a village, village council. Is there any decision by the government under section 20? Disputed members? No.
Section 20, may I repeat, my lord?
Okay, all right.
No, I'll clarify it.
Just the list sent by the GB of the petitioners was not approved. The list of the respondents were approved.
No.
Which was put to challenge. Learned single judge has gone into the matter, set it aside, and director over elsewhere. Is not it?
Just one small correction. The list submitted by the contesting party, sent by the GB, it is an admitted fact. When you are doing verification, the verification or authenticity will be done in front of them. The 6th May letter which he has written, he has clearly mentioned, as far as 6th May is concerned, we are withdrawing from the verification. That's the end of it. So there is nothing for him to see as his list is concerned, because he says, I am withdrawing, so give me another date. And withdrawing why? There was a commotion. Some village people were there, that's all. Now, he gets ideas when he finds that this is very raw. Then he introduces the concept of 4 of his persons were beaten up. I can understand in a mad crowd, 4 persons are beaten up, you cannot catch. The 4 are his own persons, beaten up from the other side. So he knew who was beaten up and who beat them. And he has not disclosed their names.
We are not going into
No, I'm not going, I'm just saying the complete attitude of that person has been this.
We will go by section 4.
Yes, section 4, section 20.
Going by section 4.
And section 20.
We are
Section 20 by which this procedure takes the approval of the government.
going by section 4. In the facts of the case.
Correct.
We are of the view that the learned single judge was perfectly justified in directing a reconstitution of a village council in the manner provided under section 4. We'll give our reasons. I think this can be, see, those are, all those factual parts cannot, perhaps may not be necessary to go into it. We will say that as per section 4, village council member is to be chosen.
Correct.
Chosen. Choosing means what? If there is no unanimity, then it has to be the majority one.
Correct.
Is not it?
Correct.
Those facts are not, those facts are not before this court. That particular clan has how many members? Maybe adult member, you say household, is not it? And was it a unanimous selection? And if not, was it chosen by the majority? So therefore, there has to be a reconstitution of the village council members. Approval given of the respondents does not indicate that it was a unanimous decision of the clan or the village
Approval given by,
or if not unanimous, it was chosen by the majority of the clan. Those are matter of fact, which is not before this court. There
I'll
is no
place-
material to
I'll
indicate.
I'll have
Yes.
one point.
This is our
Maybe,
tentative.
maybe.
We will not go
Now,
into this.
as far
This
as
is basically an
your
electoral
lordship
issue.
says, whatever has been said does not have the support of the records.
Yes.
This is what your lordship says. I am doing the records, that's not a good problem. If I am speaking out of the record,
No.
no, your
See,
lordship has said,
From where you will bring the record that this Rio village, for example, Rio is a clan.
yes,
How many households are there? Where is the evidence?
that is given here in this.
So
That kindly understand that as far as the Rio clan is concerned, it is nobody's case that these were not the members. You cannot import into something that the learned single judge may have passed. That's a different question. But here is a case, if everything is going to be suspect, where is this and where is that? Whatever is there as far as the customary practice is concerned.
there is no question of
I-
suspect here.
I have given a list. That list is based on fact written by the persons. That list cannot be disputed because the government has verified that list. What more is required? What more is required if the list is there? And secondly, I have placed very clearly that under Section 4, which is being enforced, even the additional document which was not there, even if that is placed, that is not a document under Section 4. Therefore, he has no locus standi to go ahead in this matter. That's a fact. Kindly appreciate, my lord. Kindly appreciate this fact. Maybe if your lordship is not fully convinced about it, I will also have to look afresh and I will report back. No difficulty. This is a very sensitive matter, my lord. Please understand. Today,
Where is the sensitivity?
no, there is a sensitivity in
It's a
my lord,
question
what,
of the-
what is the sensitivity is there?
It's a
I will report.
Council members.
I
It's a
will report
democratic-
back. I will report back to the honorable
It is-
court. Since your lordship has expressed your views, I will report back to your lordship's points, and then I will place certain things on record of legal prominence, which your lordship may consider. After you can decide, fix any date. Any date your lordship wants, you can be fixed. I have no difficulties. You require something. I won't vehemently press so much for a village council election. I've seen what has happened. And therefore, it is my concern to put it back. Otherwise, what happens? Election is again done.
Yes, Mr. And the Advocate General is asking for a date.
Lordship,
to bring on some.
Lordship, we have spent almost the entire first session, and almost the argument has been completed.
He is not complete.
It's almost done, my lord. and apart from this, my lord, everything is here. All the documents are here. Whatever they have placed before the single bench is here, and we can only decide on the basis of such documents only, my lord, placed before the single judge. And also, my lord, referring to Section 20 at the outset, my lord, Section 20 has been placed, given a wrong interpretation. My lord, this honorable court, a division bench, way back in 2015 has held the Section 20 reference under Section 20 of disputes deals with only filling up of a
Just a moment. Yes, Mr. Joe, you wanted to say something? No.
deals with.
You want another date?
Please, require a date. I'm grateful your lordship has been fair enough to express whatever your lordships have in your lordship's mind.
Lordship, only thing
Just-
is,
I'm
Lordship,
making a submission. Whatever your lordships have in mind, I will address these questions. And some important questions did arise. I won't say no. Like what your lordship said, I'm not asking all the questions, but many questions are traveling in my mind also.
We have not asked.
I know that. Your
Many other
lordship
questions
has
which
not
are,
asked many
which
other
are still in
questions,
our mind.
But many other questions.
Yes.
So let me address these things. Fix a date, I will come.
When?
tomorrow, man. Tomorrow?
No, tomorrow it will not be possible. When do you want?
When what date?
Today's 10th.
Today is not 17th. Yeah. Could I have it in the first week? We are having
First week of June.
first week or after second week. I have matters in Calcutta also, so pertaining to Nagaland. After second week, I am free. I will come. Subject to your convenience.
Who's coming? Lordship, it's
Yes. First week of June.
If it is second week, I have
Second week.
after second week. I will come. I have no difficulty.
Lordship on 14th. 14th is Wednesday. We have only once in a week.
Eh?
Division bench once
14th,
in
no,
a
I
week.
have arbitration in Calcutta.
14th of June or May?
June. But
June.
Lordship,
June.
June.
I am only
Lordship,
I
as,
have an
as per the
arbitration.
wish, Lordship is will be a part of my lord.
You said second week.
Immediately after second week. My date has been given by the arbitrator. It may just spill across, so that I don't want to come and take
Then
a date.
21st?
Very well.
Next,
21st?
next Wednesday is 21st. He appears have some difficulty on
Maybe,
14th.
maybe, my lord, either 3 days before that or 2 days after that. As is convenient to your lordship. I'm told by my learned friend, 21st also there is a hearing.
21st also,
We are having a hearing. So if 3 days before that or 3 days after that. Convenient, whichever is convenient. I have no problem as far as the last week of June is concerned, that entire 10 days.
he is pointing out that this only the Wednesday is a
Yes, ma'am.
division Wednesday.
Yes.
No, I think that can be changed.
It depends.
Yes.
If a special bench can be constituted, my lord,
Yes.
but usually it's normally only on Wednesday.
So you choose a date. Can be non-Wednesday also?
I'm here, my lord.
When-
AG has
when?
to come. Savito. See, just see the dates there.
24th, 25th, rather.
June 12th, Monday.
My lord, my arbitration,
19th is also Monday.
in fact, 12th, 19th, 21st, if it is 23rd, 24th, till the end of the June, I have no problem. You could kindly accommodate.
Then what, 26th?
26th, okay.
That is Monday.
My lord,
I'm
I
very
have no.
I will address these questions, and
Lordship,
maybe I may have a few questions to ask the other side also on this point, on law.
Lordship on
I'll place
26.
everything on record.
26.
26, my lord. Sorry, I have a trial matter, my lord. Fixed.
27, then what, 27?
27, okay, fine. 27, 26. 27, 28, all right, my lord. No, I have no problem.
Okay, 27th, Tuesday?
28 also
On
is
the prayer of Mr. Sanzo, learned Advocate General, with the consent of Mr.
until long, my lord.
M.T. Longa, learned counsel for the petitioner, as well as Mr. Ajo, learned counsel for respondent numbers. 17 to. Okay, 17 to 22, I think. List it on 27th, huh? 27th.
27, my lord, yes.
27th of June.
My lord, it's not part third.
No, it is not a part of.
Okay.
For orders, item number 39.
Yes, who appeals? Item number 39.
Lordship, item 39.
Yes.
Yes, Lordship, on last occasion, on 19/4/2023, the President bill was admitted, and the ELCR was called for. Lordship, I was informed that the ELCR has not reached till now.
Okay. Respondent number 2 has also been not served.
Lordship, notice was, we have served notice by registered post.
Okay, heard Mr. L. Lima Bapa.
Yes, Lordship.
Learned counsel for the appellant.
Appellant, Lordship.
With service report or of respondent number 2 as indicated in our no, as well as the LCR, as well as the connected LCR, as indicated in the office note dated 8/5/2023. List it again, in view of the list it again after
It's about 3 weeks.
3 weeks. Office to issue reminder for LCR.
Yes, Lordship.
For orders, item number 40.
May it please your lordships.
Yes.
Lordships, today is for hearing the IA number 4 of 2023. This is an application under section 389 CRPC for suspension of the judgment dated 13/3/2023.
376 2.
Lordship.
376 2.
Yes, Lordship, with
Whether you serve the serve notice to the respondent?
yes, Lordship.
It is.
Notice has been served.
No, not yet been served. Notice was issued. A return service report awaited.
Oh, Lordship.
That Mr. J. Seki, then counsel for the appellant. Office note dated 8/5/2023 indicates the service report of respondent number 2 is still awaited. View of the listed again after 3 weeks.
2 weeks, Lordship, because if my lords may kindly appreciate, I won't go into the details today, but
2 weeks, okay?
it's a false prosecution, Lordship.
Is it?
Yes, Lordship. So
You
it's
want to
not
take
fair.
fresh steps?
Yes, my lord. If my lords may allow me, I may be allowed to publish it through
No, not.
substitute notice through a newspaper. That way, the matter can be adjudicated a little early. This matter deserves the early attention of this honorable court.
Substituted service is permissible in criminal proceeding.
Lordship, that I'm not very sure, but substituted notice, it should be permissible. Lordship is the same.
Yes, PP.
It's the same, Lordship.
You take fresh steps by Seki. You take fresh steps by register post as well as by usual
Or through
process.
the, my lord, through the
Usual process.
OC of the concerned police station.
Okay.
If this-
Junemoto.
Yes, Lordship. If the same kindly be reflected in your order, Lordship.
Mr. Lemal and counsel for the appellant and Mr. You are PP.
Lordship,
Okay,
Vijayamomi.
Vijayamomi. In view of the office note dated 8/5/2023, the learned counsel for the petition shall take fresh steps for service of notice upon respondent number 2, which shall be served through the jurisdictional police station.
Lordship.
Listed after
2 weeks, Lordship.
2 weeks. Okay.
My
2
lord.
weeks is enough. Okay, 2 weeks.
Or 3 weeks then, Lordship.
3 weeks.
Okay, Lordship. Oblige you, Lordships.
For hearing, item number 42.
May it please your lordship.
Yes.
The short fact of this case is that the petitioners were appointed to grade 4 posts. While they were serving, the department decided that their appointment was without sanctioned posts. All right. So their pay was held up and inquiry was conducted. A case was given to the Vigilance Commission to verify the petitioners' appointments as to whether they have been appointed against existing vacancies or not.
Which post? Which post?
Grade 4 posts of.
Grade 4.
Yes, grade 4
Grade 4
in the districts.
in the district.
Yes. Medical department, your lordship.
Okay, medical department.
Yes. So they were appointed between 2004 to 2009, the petitioners. Then in 2000, some were appointed by the CMO, as per the government notification.
Grade 4 post in which capacity?
Grade 4 posts
Ad
like
hoc,
Mali.
contingency, Casual, what? Fixed pay?
Initially 4 of them were appointed as contingency.
Ah.
The petitioners 1 to 4. On contingency basis, by the directorate. Then later on, the CMO converted their contingency appointment to temporary appointment. According to the government, temporary appointment means regular appointment. That is what the government, the department is stating. So the CMO converted their initial contingency appointment to regular appointment. Then the other petitioners were appointed by the CMO on temporary basis. The appointment is temporary appointment, Your Lordship. Then what happened in 2012? 2012, the department decided that they have been appointed against non-existing vacancies. So in order to terminate their...
No, 4 of the contingent employees were made temporary subsequently.
Subsequently,
What
in
happened to the
2009.
rest of the employees?
The other petitioners were appointed temporarily.
Okay.
The other petitioners, only the 4 petitioners, the first 4 petitioners, they were initially appointed on contingency and converted to.
Okay.
Yes.
Others means rest of the 14
Yes.
petitioners were
14 of them.
appointed temporarily.
Yes.
Okay.
Now, vigilance inquiry was sent. The vigilance finding is that there is no vacancy shown against their appointment. So they were appointed against non-existing vacancy. That was the finding of the Vigilance Commission.
Okay.
Now, in 2012, so in order to have this inquiry, what happened was in 2012, the pay of the petitioners were held up. In 2012, pay of the petitioners were held up by the department pending the inquiry. Then immediately after the petitioners' pay was held up, they started appointing the present private respondents.
Okay. How many private respondents?
From
18.
respondent number 5 to 41. Respondents number 5 to 41. So it will be
More than 18.
30, above 30.
Okay.
Your Lordship, above
Yes.
30.
Yes.
So all these were appointed. Now, when show cause notice was issued to the petitioners stated that we are supposed to be without any vacancies, appointed without vacancies, but you are appointing this many immediately after our pay is held up. So it is a case of replacement of ad hoc by ad hoc.
You filed a writ petition then?
Yes.
Then what happened?
Then what happened is the learned single bench decided that since we were appointed without vacancies, we have no right, but the respondents who were appointed, though they have been appointed, it is up to the department to decide to make such appointments. So we will not interfere with the appointments of the private respondents. Since you were appointed without vacancies, you have no right even against this subsequent. We are saying that no.
You are challenging that
Yes,
part of the...
we were challenging that. We are not challenging anything else.
that part.
Yes, only that.
Now the
Yes.
private respondents have been served.
Yes, notice is complete, Your Lordship. Your Lordship will see notice has been
they are
complete,
not
everything has been completed. Even newspaper publications had to be resorted to, and then 2-3 times we had served the notice, Your Lordship.
Yes, their appointments should
It is
also
to be
go then.
heard. So that is the brief fact of the case, Your Lordship. From 385, starting from page 385. Your Lordship, the findings will be, the reasoning of the learned single bench starts from page 415.
Page number?
Page 415, Your Lordship, 415.
Judgment starts prior to that.
From the top, Your Lordship, the argument, if I may read, Your Lordship, page 415.
Yes.
415, Your Lordship. The argument of Mr. Tompo Commander, learned counsel for the petitioner, that right after removal of the petitioners, some other people were appointed. And that-
418. His number?
415. 415, Your Lordship.
Yes. Yes.
Yeah, what the learned single bench has essentially stated is that appointment of the others is of no concern for the present petitioners because they cannot show that they have been appointed against clear vacancies. So ultimately, the learned single bench directed that the back wages till their termination be given the petitioners, but with regard to the challenge to the appointment of the private respondents, the court has refused to entertain it, Your Lordship, in brief.
Yes, where is the finding?
So from page 415, if I may read,
Yes,
it makes
yes.
things clear. The argument of Mr. Tongpo Commoner, the first paragraph, there's a ending of the preceding paragraph, but starting from the next, that is the argument of Mr. Tongpo Commoner, learned counsel for the petitioners, that right after removal of the petitioners, some other people were appointed, and that shows that there were sanctioned posts. And the petitioners were appointed against such sanctioned posts does not hold much water because the learned senior additional advocate general, Mr. K. Sima, has submitted that the persons who were appointed after the removal of the petitioners were appointed against non-sanctioned posts and on ad hoc. Secondly, existence of sanctioned posts at the time the petitioners were appointed will not make any difference unless each of them were appointed against specific sanctioned posts. Unless the petitioners prove that there were vacancy and they were appointed against specific sanctioned posts, their claim that their legal rights have been violated has no basis, and when they have no legal right, no mandamus can be issued. Further, on perusal of the report of the Vigilance Commission and the other related documents, I find no reason, no doubt on the finding made by the Commission. It appears to me that thorough inquiry has been conducted before arriving at a conclusion. As such, there can be no other conclusion that the petitioners were appointed without sanctioned posts and therefore their appointments were illegal. The second issue involved in this case is whether the petitioners were given chance of being heard or not. By their very admission, the petitioners were given chance of submitting representations after representations, besides appearing before the vigilance police. Their representations were also submitted after the show cause notice was given. Perusal of the show cause notice and the representations submitted by the petitioners show that sufficient opportunity was given to the petitioners to submit their case. Therefore, the plea of the petitioners that they were denied the opportunity of being heard does not appear to be correct. The third issue involved is whether by applying the principle of first come, last go, the petitioners could have been retained on ad hoc at least since they had been appointed, regularized, and serviced rightly or wrongly. As already stated while discussing the first issue, the petitioners have no legal right over their appointment since the same was illegal. Therefore, they could not have been retained on ad hoc in preference to the newly appointed persons. The appointment of the private respondents has nothing to do with them. The government has the power or right to appoint to meet exigencies, and that has nothing to do with the petitioners who were dismissed from service as their appointments were not against sanctioned posts. The fourth issue involved is whether any discrimination have been committed against the petitioners or not. When such question is raised, the first thing the petitioners must prove is that they had a legal right. Without that, they could not have made a valid or legitimate claim of being discriminated. For the question of discrimination would arise only when one has a legal right as stated above. In other words, since the petitioners were appointed against non-sanctioned posts, they have no legal right over their respective appointments. As such, the questions of discrimination does not arise. The last issue is whether the petitioners would be entitled to their pay and allowance from the date their bays were held up, that is 1/5/2012 till the date their services were terminated, that is 29/4/2015. This issue has been settled by a division bench of this High Court in WA number 11K of 2017, which arose out of two writ petitions. WBC number 105K of 2015 and WBC number 113K of 2015. In that, the court had decided that the appellants, the petitioners in the two writ petitions, should be paid their salary for the service rendered by them. The appeal, as stated, arose out of the judgment passed in the two writ petitions, in which the learned single judge in a similar case had dismissed the prayer of the petitioner to quash and set aside the order dismissing them from service, and also to direct the respondents to pay them their salary for the same period. As in this case, the state respondents, not being satisfied, had come to the Supreme Court by filing SLB, and the same was dismissed. Following the same in other similar cases also, this court had allowed such prayers. Taking into consideration the above facts and circumstances and the facts that the petitioners were serving and their service were utilized by the government during the period between 1/5/2012 to 29/4/2015, this court is of the view that they also should be paid their salary for the said period. Accordingly, the state respondents are directed to pay the salary of the petitioners for the period from 1/5/2012 to 29/4/2015, within a period of 3 months from the date of receipt of a certified copy of this order. However, as for the prayer for quashing and setting aside the impugned letters, OMs, corrigendums, show cause notice, and the orders, the same is not considered too. So this is the perfunctory manner in which the decision has been rendered. My case is that they could not have appointed the others when our matter was pending.
In which paragraph it has been dealt with? Appointment of the others means the private respondents?
Other private respondents are at paragraphs from the two learned senior advocates, starting from paragraph 17, 411, Your Lordship, their submission.
411.
Yes, 411 page.
No, not
paragraph
the
17.
submission. Where has it been dealt with by the court?
Only the submissions, and then the conclusion of the learned single bench is the one which I have read out.
Where is the
Yes.
discussion?
No, only that much. This is the submissions of the various respondents are there, and then the discussion with regard to Maya.
Okay.
Lordship. after our pay was held up, and when so-called inquiry was going on, they appointed all the private respondents.
No, that's all right.
Yes, that is,
what
so
was the
my,
ground?
my ground is that, first is that it is a case of, since technically we were still in service.
No.
No, technically we were, my ground, your lordship. I'll just say my grounds, two main grounds. My main grounds is that since we were still we had not been terminated. We had not been terminated.
You were
Only-
there in a
yes.
non-existent
Then
post.
Even the others were appointed against non-existent posts, your lordship. Even the private respondents were not appointed against non-existing posts, your lordship. It is very clear. Even in the affidavit also, it is very clear, your lordship. In the affidavit of the state respondents, your lordship.
Okay,
If your
you-
lordship may allow me to take your lordship to the affidavit. Page 263 is the affidavit filed by the
No,
state
first,
respondents.
your ground of challenge. In the
Yes, my
reputation.
ground of challenge is that it is a case of juniors replacing the seniors. No. Since it is not juniors replacing the seniors, my first ground is that in this case, first come, last go should have been applied. That since we were already there,
Let us
since-
see your
that was my
reputation.
one ground.
Let us see your repetition.
Yes.
Relevant paragraph.
Page 80, your lordship.
Page
Page 80.
80.
80, with
Yes.
regard to the ground which I have raised.
Yes.
That from the appointment of respondent number 5 to 44, after the establishment, under the establishment of the CMO, Mogokchong, subsequent to the holding up of pay of the petitioners, it can be concluded that either sanctioned posts in excess of the posts held by the 33 employees, including the petitioners, were available, or that the appointment of the said respondents have been made in anticipation of the termination of the services of the 33 employees, and considered either ways, the conclusion cannot but be that, contrary to the stand of the department, the petitioners were actually appointed against sanctioned posts. It would be preposterous on the part of the department to now take the stand that immediately after the holding up of the pay of the petitioners, vacancies to accommodate the 40 respondents arose or were created. And even if such a stand is accepted, it would still not be sustainable as the appointments were made without giving opportunity to the petitioners and or other eligible candidates. Therefore, so long as the 40 respondents are allowed to remain in service, the state respondents cannot validly terminate the services of the petitioners. That is one ground, your lordship. Number two, paragraph 40, the colorable exercise of power is apparent in the action of the state respondents in that the dismissal of the petitioners from service is to serve the improper purpose of accommodating the respondents number 5 to 44 against the resultant vacancies. 41, that the petitioners having been terminated to make way for appointment of the respondents number 5 to 44. The appointments of the state respondents amounts to ad hoc appointees replacing regular appointees, which is not permissible under law. 42, that in the instant
These
case,
private respondents were appointed as what?
I'll take your lordship to the appointment orders, your lordship, the imbued appointment orders.
No, just
Your lordship, because I don't want to read things which are not there in the order, so.
you were appointed as what?
We were appointed as some, since this is grade 4, all of them are grade 4, same pay scale, only in some case medical attendant, in some cases chowkidar, but all are in the same category.
And there's private respondents?
Private respondents also in that same category.
Grade
Some are
4,
medical,
various-
some are medical attendants, some are chowkidars.
Is there a
So-
recruitment rule for appointment of a grade 4?
There should be.
There should be.
There should be publication, of course. Your lordship already knows.
No.
It's a matter of, but in our
Is there a
case,
recruitment rule?
there is no recruitment rule, your lordship.
Okay.
There is no recruitment rule at all.
Then how it is appointed in a regular manner? If the state wishes to appoint anybody as a grade 4 employee in accordance with the constitutional scheme of public appointment, then how do they appoint?
They directly appoint. Nowadays, what happens is, nowadays,
There's no recruitment rule.
it is sent to the government, any kind of candidates, they will send to the government.
No,
The
no, no.
government
What
will-
the government do, we are not concerned.
Yes.
Is there any recruitment rule or not?
There is no recruitment rule.
Yes, there's no recruitment rule.
No recruitment
Then
rule.
how do you appoint?
Against a sanction post?
Against the sanction post?
Yes.
On a pick and choose basis?
Not pick and choose, but
Okay, then how
most
do
of
you
the
appoint?
cases, it is done through the interview
Ah.
against a sanction post interview by the department, concerned department.
How do you do the interview? On what basis?
No, it depends on the post.
It depends on the post.
Yes, the integrity of the
Okay.
applicant.
If it is a chowkidar, then what kind of interview?
Because here we are
Huh?
we are going in such a very peculiar, unique state.
Unique state.
Unique means in the sense, you see, appointment of executor mostly, and most of the department equals to the landowner. Landowner, because land is not acquired by the state. So on many occasions,
These private respondents are appointed on a landowner basis.
no, just to meet the exigency.
Don't mix up things.
Yes.
Huh? Landowner, I know, you know.
Yes.
Is the land ownership involved in this appointment?
Your Lordship, I'm not clear about this.
You're not clear about this?
Yeah, but in order to meet
Then
the
how
exigency.
then how will you argue the case? Today it has come up for hearing.
Yes.
We are here to dispose of the matter. Huh?
Because I have
What is
also,
your good name?
in team, so I have taken up only recently this appeal. It was handled by other council.
Are you ready or not today?
I need to clarify some point, like appointment of the subsequent.
See, in the
appointee.
first half, you had requested us to reassemble two. At your request, we have reassembled. Now, you said that you have to clarify some. What is to be clarified?
But those subsequent appointees are landowner or not, just to clarify.
See, everything is a matter of record now.
Yes.
Have you gone through?
Yes.
Have you gone through the record?
Yes.
Then is in the record, is there any mention of an appointment on a land ownership basis?
No, in the petition, in the earlier petition, their claim is because of by virtue of the landowner, they were appointed.
You are a senior government advocate.
No, I'm an additional AG.
You are an additional AG.
Yes. The problem with this, Your Lordship, here, most
shall
of the
we-
cases I have taken up recently only.
Just a moment. Shall we proceed with the case today? See, if you conclude your argument, we'll pass the order. You don't know.
No, because it is a bill. So whatever objection raised in the repetition, I have to reiterate only that objection only. Because the crux of the case, the crux of the issue involved in the present case
No,
is
see-
illegal appointment.
Are you ready with the case?
No, except that I can.
Mr. Pongana, ask him whether he is ready to argue the case today or not.
He is ready.
Yeah, we can go. But Your Lordship, that the 50 appointment, subsequent appointment, I'm not so clear about this. The reason to, I have to reiterate the objection raised by the
Whether you are clear about the case or not, we are not concerned with. Huh? That is your lookout. Are you ready to proceed with the case for final disposal today?
Well, good. Yes.
Huh? Yes. Is there a recruitment rule for appointment of a grade 4 post?
I need some more time to take instruction.
Mr. Pongan, you
Because-
look at the additional age of your estate. On the
Because-
prayer of Mr. Your good name?
In team, so.
Huh?
In team.
So Leonard, the additional age you listed next week.
No, Your Lordship,
Next,
it cannot be taken up
Wednesday.
by Justice K. Sema. It cannot be taken up by
Okay,
Justice
okay.
K. Sema.
Then
This matter has been pending for so many years because either of the
After-
two judges are always sitting.
Okay.
So I
After-
decided to take this opportunity to take it up before your two justices, but if that is the case, now it will
But you have
again
seen-
go back to 4 months. The
Yes. We'll say after 3 weeks.
4 weeks. Whole week, case now will continue, no? Whole month.
Yeah, Justice Kohima will be sitting for the entire month, it seems, Your Worship.
Okay, in the month of June, we'll say.
Your Worship, Your Worship.
On the prayer of Mr. So-and-so, learned additional advocate general, listed for hearing in the month of June.